Very good evening to all. Welcome to Verdictum. So today we are here to discuss a very important issue, which is the interference of law in religious issues, which has always been debatable, and there has been several instances when the court has come up to decide not on certain religious issues and made important precedents. The court have not only protected the rights of citizen under Article 25 of the Constitution, but also on the same hand, it has been felt that the freedom of religion has been infringed by a lot of judicial interference that led to an increase in litigation and aroused a question that how far is it justified to adjudicate on religious matters. For discussing this issue with us, we have with us Mr. Ravi Lochan, who's a finance professional and the trustee of Indic Collective Trust and People for Dharma. Welcome to Verdictum, sir.
Thank you. Good evening.
So first of all, tell me about this Indic Collective Trust and People for Dharma, and what is the objective of this organization?
People for Dharma was the trust which was initially started by us. The primary purpose for actually forming the trust was actually to represent the version of women devotees regarding Shabarimala traditions before the Supreme Court. To be very honest, that is the reason. And then it expanded its scope to try and understand what problems are being faced by our temples, by the various Hindu communities across India, or for the matter Indic communities. So from People for Dharma, we are primarily targeting the religious issues. We are basically what you can call as agitators in a very legal way. We agitate before the court. Someone has to actually place the facts of Hindu religious practices before the court, because unfortunately the court is not really adept in these matters. They're legal professionals. They're not really religious leaders to understand the crux of Hindu religion, to be honest. Indic Collective Trust is a trust which was formed with a wider scope, where we take up not merely the religious issues, but also fundamental cultural as well as the social issues related to the various Indic communities, not merely Hindus, but also the Jains, the various pagan traditions of India, for that matter. Because unfortunately, the Abrahamic side of the religious divide is always very clear in representing themselves before the court in all matters, whereas the Indic pagan side doesn't have such representation. So ICT takes up the cause of the Indic communities in India, those who are the Bhumiputras of India, to be honest.
Right. So since you have worked a lot for the protection of Article 25 of the Constitution, as you say, and especially in the regularization of temple administration and function, so sir, in your view, is government intervention necessary for the management of temples and the religious endowments?
I have not seen a single instance where government interference has actually resulted in a better management, to be honest, in the long run. At max, people can say that initially for a couple of months, some system was brought in place or whatever. But in the long run, government interference has always been a negative influence, especially with regards to the religious aspects of the temple. Now, that is the primary purpose of temple itself. The primary purpose of temple is puja and devotion to the deity, and that always takes a back place. You know, it takes it not just a back seat, but perhaps it goes I don't know, a few kilometers behind the main objective of whatever the HRC department has. So no, there is no need for government to actually interfere in temple management. The maximum that can be said is that some amount of auditing can be done, perhaps to ensure financial propriety, but that is always possible. Any trust can be audited for that matter. The government need not actually interfere in administration of temples. A secular government, for that matter, has no business entering my temple, because specifically in the Indic context, we don't have anything called secular and religious. For us, everything is religious in the sense that जब पूरे विश्व ही भगवान से भरे हो, we believe not in just an omniscient God, but an omnipresent God. So how can anything be secular for us within a temple? So there is no point of splitting secular and religious within the temple precincts. In that case, the government has no business entering my temples.
So as you mentioned that the interference of government is, it must be to the extent to the financial management. So recently, former Supreme Court Judge Indu Malhotra, there is a video which has been viral, and she commented on the communist government trying to make all the temple, to control all over the temples for revenue. And we see in general, all the major temples of India has been directly or indirectly being controlled by the government. So do you advocate the view that the temple must be made autonomous?
Of course, yes. I always ask a question, why should they not be autonomous? What is the reason for government to interfere here? There are only two reasons which are given, and both of them are spurious. One reason is that apparently if government doesn't run these temples, doesn't manage these temples, then the Harijans will not be allowed inside the temples. This is a nonsensical argument. Temple entry is legislated. Not allowing temple entry for Harijans is a crime in India, and a great number of temples are managed by private parties, and none of these temples have issues regarding to temple entry. And if there is a problem, there is always a legal solution. There is no reason for government to actually take over temples here. Second reason that is advocated is that there is a huge amount of money in these temples. It may be mismanaged. The biggest corruption happens in India in government sector. Even in private hands, the people may not be very ruthless with regards to corruption. There will be some amount of fear regarding court, the jury, the police, and other stuff. But if you're a government servant, you're a government babu, you don't fear anything. So to actually claim that government interference creates a corrupt-free temple management is the biggest nonsense that you can ever hear.
Okay, so since we discussed about Justice Indu Malhotra, so she was the only judge who gave a dissenting verdict in the Sabrimala judgment, where she mentioned, and I would like to quote, that the right to equality under Article 14 in matters of religion and religious belief has to be viewed differently. It has to be adjudged amongst the worshipper of a particular religion or shrine who are aggrieved by certain practices which are found to be oppressive or pernicious. So my question is, since the judgment held as the protecting the rights of women under Article 14, 15, 25, but if you see, the restriction is for the women under the age of 15 to 50, and under the belief that Lord Ayappa has manifested as Naishtik Brahmachari. So how in broader sense does the case hold its relevance when the case is actually not being filed by the people who hold the faith, but by the association, obviously interveners who are involved in social developmental activities, especially activities which is related to the upliftment of women and helping them, becoming aware of their rights. So what is your take on this?
See, that has been our primary concern as well. In fact, one of the main arguments that we have against the petitioners, as well as whatever judgment has been given, against which we have filed a review petition for that matter, is that those who have faith in deity, they follow certain practices and traditions and certain restrictions with respect to the deity. If you don't have faith in the deity, then you have no business talking about the deity. It is a very simple fact. And this concept of Naishtik Brahmacharya is not exactly, related only to males either. Even a female can be a Naishtik, a celibate for that matter, a Brahmacharini as they call her, the traditional text. So if Devi is manifested in that form, then generally males will not be allowed inside. And of course, in Hindu traditions, you have Navratri Puja, which is going to come very soon for that matter. And in Navratri, you worship young girls. You call it as Kanya Puja in southern India, Kanjak bolte hai in northern India. Yeah. So should the boys now go to the court and say that we want equal rights? Even young boys should be worshipped in Navratri. I mean, let us have some idea of sense here. A blind secular application of Article 14 in religious matters is nonsensical. And it has no place in Hindu religion, which is extremely diverse for that matter. Every community, every gender, every caste, every practice has its own place, and they have been given a specific ritual space as well. So why do you want to collate everything and make it into a one single organizing? I mean, I don't know. It's like you're trying to Abrahamize my religion. I don't want that. Why would I be okay with it? And certainly these people who don't have any faith in the deity, let them stay away from my deity. They have no business here. No one is forcing them to come and pray at Lord Ayyappa's temple. If you have belief, you can come. Else you can always build your own temple and pray. We don't have a system of issuing fatwas saying that XYZ temple is illegal or it is immoral, whatever. You can always believe in something, you can build your own temple. In fact, you can build a temple and say that only women will be allowed inside the temple. I don't have a problem with that. It's a very simple concept.
So coming to this religious freedom. So in Karnataka, the Karnataka Protection of Rights of Freedom of Religion Bill 2021, which grants autonomy to approx 34,563 temples to be introduced by the Karnataka government, as mentioned by the Karnataka CM in his budget speech. So do you think a uniform bill is required to give an autonomous status to the temple, or some regulation must be kept to avoid the misuse of funds?
I really don't understand the idea behind an autonomous body. See, to be honest, I would say there should be some regulation, financial regulation, not exactly regulation, but more like an auditing or asking those trust to file audit reports for the temples. That should be sufficient. Nothing more is required. Or perhaps you can say that just as government departments are being audited by the CAG, you can have the CAG audit the temples as well, the temple accounts. There is no problem there. But if you want to set up an autonomous body for regulating temples, then I would prefer that such body actually gives importance as well as a method by which the various sampradayas can manage their own temples. See, the issue with Hindu temples is that we have a huge variety of sampradayas, and each sampradaya is unique. You cannot have a person from a different sampradaya, managing a particular temple. That will always create problem. There are exceptions in the sense that traditionally there have been some temples where a community of people have come together and managed it, though the internal pujas will belong to one particular sampradaya alone. But even there has always been a very clear demarcation. In Tamil, we call it as Ulturai and Veliturai, in the sense that it is internal and external. So the internal relates to the puja and the Garbhagriha, the external relates to the other administrative matters. Or a similar differentiation exists in Karnataka for that matter, or even Kerala. So that demarcation should be there. Even in Jagannath Puri, you have that. Bitarcha Mahapatra is the one who heads the internal affairs of the temple, whereas all the affairs, including the external and the internal, will be handled by one Parjoshi Mahapatra. So this demarcation is very clear. The sampradaya is always there. So if a government wants to actually create an autonomous body, will it be creating a body for each of the sampradayas? I don't know. So perhaps the best way is actually to ensure that every temple is given to the sampradaya itself, and you have an autonomous body which takes care of the audit and other stuff, financial regulation or other financial supervision, or however you call it, with the least amount of interference as possible.
Okay, so there has been one more serious allegation which I would like to discuss. It's there on the state government that the land allocation and auditing, what we are discussing earlier, has always been done in a biased manner. That the land by the Hindu temples have been allocated for construction of other institutions, and only Hindu temples, including the local temples, has been audited by the government. And your organization and many others has also filed petition in Madras High Court on a similar issue. So what are your views on it?
See, it's a very funny thing in the sense that if you take the case of Hindu temples which are managed by individuals, they are taken over by government on flimsy grounds without even proving any mismanagement. All they require is some kind of a charge by any one disaffected person who could be from the party itself. from the ruling party. The government wants to take over the temple. Some guy from the ruling party will just send a letter. Based on it, they will take over the temple. Whereas there are some 40,000 temples, 45,000 temples with government in Tamil Nadu. And none of these temples are external audit. So you ask the highest amount of propriety from temples are managed by the public. Whereas when temples come into your hands, you don't do audit. You lose lands left, right, and center. Tamil Nadu government has stated before the Madras High Court earlier that they lost 50,000 acres of land. Now they are saying they have lost another 1.3 lakh acres of land. I mean, it's the most nonsensical thing that could ever happen. In the name of supposedly managing temples better, you have somehow lost 1.8 lakh acres of land. Vatican is hardly 250 acres of land. Imagine that. So we must have lost more than 700 Vaticans in size in Tamil Nadu alone. So this claim that government can manage temples better is nonsense. Auditing temples alone is of course bias only because take the case of Kerala. There was a bill which was introduced to merely audit churches, not even regulate them, just to ensure that auditing is done properly. And there was a hue and cry from the church managements across the state. Government dropped it. Whereas in case of temples, it is not merely audit. You require n number of things for the temples, and you take over the temples and then don't even do audit. It is not even double standards. It's multiple standards for difference. You can see maybe. Of course, for Muslims, it's a bit more dicey in the sense that their places of worship are not under government, but Waqf board are generally the trustees are appointed by the government. But then beyond that, there is no real interference by the government. In case of Christian churches, there is no such interference at all. Complete non-interference. So maybe we have first grade citizen, a second grade citizen, a third grade citizen. Third grade is of course the Hindus. That's the situation. As for land allocation, because government controls temples, and temples are huge land banks, whenever they have any requirement for any public project, they will immediately take over temple lands. Madras High Court has actually given a judgment which states that you should not do it. That temple lands shall be the last land which shall be taken over by the government. They should always try for other lands first. But in reality, in practice, they always target temple lands. Best example, in Chennai, there is one metro station, Egmore metro station, which was built on a temple land. The station was built, and after that, they issued an advertisement calling for objections from public. Imagine this being done to any church or a mosque. Impossible. But has been done to our temples.
There has been a serious issue in Kerala, I think, where the land reform legislation in Kerala have been specifically targeted as per Hindu activists. So how much truth is there in that accusation? And you have also filed a petition in Kerala High Court demanding just rental compensation for the lands of Sri Padma Swami Temple. So please elaborate on that issue as well.
Kerala is a unique case in the sense that land reforms legislations were passed there, and they excluded plantations from this legislation. Now, on the outset, it doesn't appear to be biased based on religion, but in reality, it's absolutely biased because most of the churches in Kerala, they owned only plantations. They did not own paddy fields, whereas temples generally own paddy fields. By excluding plantations, you ensure that the churches are left with their land bank, whereas all the temple lands have been taken over by government because paddy fields are not exempted. So it is a very clear case of a biased legislation being passed by the state, which has deprived the Hindu institutions of their lands. Now, even here, the fact is that you have taken over a public land which belongs to the Hindu community, and you're distributing it to individuals. So what kind of social justice is this? Is a question. The community land has been now given to a handful of individuals. There is no real social justice. In fact, to ensure that the community good continues to happen, the government is required to pay an annuity as rental compensation for these lands. Now, this rental compensation, the annuity should have been determined based on the actual rental value of these lands by the government. The Land Reforms Act was passed sometime in the 1960s. It has been 60 years now. Till now, a final, you can say, a final settlement has not been made. There is no final settlement regarding this rental compensation at all. They are giving some ad hoc payments till now. So these ad hoc payments, they are a pittance compared to the land which has been taken over. Again, I can give some examples. Cochin Devaswam Board, it controls about 400 odd temples. At the time of independence, the Devaswam Board had 55,000 acres of land. This is recorded. Now, if you take the case of this land alone and presume that it is entirely paddy fields, which is actually not so. A good chunk of the land would be residential or commercial property now in Kerala. If you consider that, the annual rental compensation would run into several thousand crores, to be honest. But even if you presume that it is entirely paddy fields, still the amount of annual rental compensation that Cochin Devaswam Board alone has to receive from the Kerala government would be in the would be something close to 120, 150 crores per annum, right? Whereas the Kerala government doesn't pay even 5 crore rupees per annum to all the temples in Kerala. I'm talking about only Cochin Devaswam Board. You have Travancore Devaswam Board, where the lands were enfranchised by the princely state of Travancore itself in 1922. And there in the press communique, they have stated that the government is liable to pay for all the expenses of TDB. Because the lands which were enfranchised by the state government or the princely state at that time, they were capable of earning more than enough money to meet all the expenses. It is accepted, it has been stated so. And as per our constitution, the liabilities of the earlier states have passed down to the successive states. So the liability of Travancore state belongs to the state of Kerala now. Travancore Devaswam Board's annual budget is about, I don't know, 400, 500 crores, 300 crores, whatever it is. The entire amount should be paid by the Kerala government. They don't do it. They hardly pay 1 crore rupees per annum. And they claim that they are supporting the temples. What nonsense. The amount of money that you pay to the temples is not even a small fraction of what you are supposed to pay.
But sir, Kerala government as well as Tamil Nadu government claims that they, allocate money from state budget for temples, and that they do not use or take away funds from temples. So whether such expense is even constitutionally valid when the government is supposed to be secular?
Technically, the government is not supposed to make religious expenses. I agree. But in this case, the government is not actually making an expense on my temples. That is what we try to say. This claim is so spurious because you have taken away so much of temple lands, and as compensation for that, annual compensation, if you pay the just amount, which will not be supporting a religion, but rather the government behaving in a just manner, right? That amount will be multiple times or perhaps 100 or 150 times of what they are trying to pay. I'll say trying to pay because they claim that they have paid so much money, but in practice, it is for, in many cases, what they claim as contributions to temples ends up as money being spent on infrastructure around the temples. Now, my question is, so would the government say that the money being spent on infrastructure around the place of worship of other religious places as financial support for those religions? Of course, they don't say so. So why do they use that for Hindus? And in most of these, temple towns, when devotees come there, of course, they expend money. They go to restaurants, they have to stay in some hotel, they have to travel by some bus. Even when they, fill petrol for their vehicles, everywhere they pay taxes. The government is earning from their devotional visit. It is not as though you're not earning taxes. In return, you're giving facilities to these people, the Indian citizens. So please, don't make a mockery of the government budget by claiming that all these expenses are for temples. I mean, it is nonsense. And my simple statement is that, let's take the case of Kerala alone. The Kerala government should be paying anything close to 1,500 or 2,000 crore rupees at the bare minimum to all the temples in Kerala, if they want to even show themselves as a least bit just towards Hindus. In the case of Tamil Nadu, the amount will be even higher. The number of Inam lands that have been lost by temples because they were under HRC, Department of the Tamil Nadu government, which did not bother to ensure that the lands are not lost, is phenomenal. And as I said, these lands are community lands, in the sense that when a temple owns some amount of land, the land is used for the benefit of the temple. The temple is for the benefit of Hindus, right? So both spiritual and economical, on both sides of the world, to be honest. So any attempt to actually take away these lands from temples is not social justice, in my opinion. If you still want to do it, then you ensure that the temple is not losing a single paisa. Whatever income could have accrued to the temple from those lands, the government has to pay for eternity to these temples year on year. And if the government starts doing it, then to be honest, the poor Hindus will not fall prey to soul vultures. The temples will have enough funds to take care of everyone.
Right.
The temples of Tamil Nadu and Kerala used to have huge annadhanam. They used to give a huge amount of feast. Food used to be distributed in the temples. Nothing happens now. So any claim of good management by any government department with respect to temples flies in the face of facts.
Okay. So coming back to what we discussed in the beginning, that on the final comment, I would like to ask from you, according to you, to what extent judicial intervention is necessary in religious matters? Is there a thin line that must be drawn so that the religious belief must not be in peril and the constitutional rights must be conserved as well?
See, perhaps we should have a system which is similar to that in Israel. You have religious courts which deal with religious matters, and you have secular courts which deal with secular matters. So you have a religious court for the Jews, for the Arabs, just separate. Something similar in India would be better, maybe, because the secular courts of India, most of them are not trained on religious matters. Perhaps 60, 70 years ago, those who used to sit and decide in the Supreme Court benches on the Madras High Court, perhaps they were, grand people, or they had great knowledge of the religious traditions across India. Not so anymore. We have become too secular. Our education is too secular. So the number of Sanskrit or Persian scholars that you find among the judiciary now would be very few. So I don't see how the judiciary is equipped to actually deal with these matters in a proper manner. They have to deal with it on both sides of the matter, as a theologian as well as a jurist. Unfortunately, most of them are not trained to be a theologian. So and they have sort of lost the ability, perhaps, or perhaps they have not gained the ability to be a theologian, to judge on these matters. What it results in is that they look at everything through a colored glasses, you can say, and perhaps they're not able to understand the diversity of the traditions here either. So you can do either of these things. Either you can have a separate religious court, or perhaps you can have a training session for the judges, so they can first understand the diversity of traditions here, and then they can think of interfering in religious matters. Otherwise, it is only going to create unnecessary problems.
So thank you so much, sir, for this session. This was actually insightful and gave a perspective on what actually should be and how should be the intervention should be. So thank you so much, sir, for coming on to Verdictum. We are looking for more such wonderful conversation. Thank you so much,
Thank you for having me here.
Thank you so much, sir.